some practice questions based on the sections of the rules that our course has already covered. We're going to practice these questions in the exact same way using the exact same approach as we did for the first set of practice questions. So turning to question number 1, the facts state, 3 women were charged with armed robbery of a liquor store. 2 of the 3 women met together with an attorney. The 2 women asked the attorney to represent them in the criminal matter. The attorney decided to talk to each woman alone prior to agreeing to represent them jointly. The attorney was told by both women individually that the third woman was the guilty party. Both women explained to the attorney that the third woman said she needed to grab something to drink from the liquor store and that she robbed the cashier while they waited outside. Both women stated they had no idea that the woman intended to rob the liquor store. After interviewing each woman separately, the attorney agreed to represent them both jointly. Shortly before trial, one of the women that the attorney represented decided that she wanted to take a plea deal offered by the prosecution and testify against both of the other women. It is proper for the attorney to do which of the following? So just like we did last time, the first step after you've read the facts and the call of the question is trying to articulate the rule that's being tested. And then we'll apply the rule to the facts and we'll try to reach a conclusion on our own. So this question is testing conflicts of interest, specifically current client conflicts. Why? Because this lawyer is now technically faced with the issue of one client turning on the other. One client now wants to take a plea deal and as a result, testify against the other woman, one of which the lawyer is representing. So this amounts to a current client conflict. The rule states a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists in 2 scenarios. The first is if the representation of one client will be directly adverse to another client, or if there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by a personal interest of the lawyer. So, stopping there. Here, we very clearly have a current client conflict because the lawyer's representation of one client will be directly adverse to the other. The clients are against each other since one will be testifying against the others. But before we stop our analysis, we need to determine if the rules say anything about the lawyer's ability to move forward when they do have a current client conflict. Well, the rules state that even if there is a current conflict of interest, a lawyer may represent a client if the lawyer reasonably believes they can provide competent and diligent representation to each of the affected clients. The next requirement is that the representation is not prohibited by law. The third requirement is that the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or proceeding before a tribunal. And the fourth requirement is that each affected client gives informed consent confirmed in writing. Therefore, this lawyer cannot get around his current client conflict. And that's because one of the requirements, as I previously stated, is that the lawyer is not representing 2 people in the same proceeding or same action that are directly adverse to one another. And here, that's exactly what would be going on. He would be representing one of the women who is now taking a plea deal, testifying for prosecution, and simultaneously representing a defendant claiming that they didn't commit the crime. So he would be representing someone on both sides of this case, which is a problem, and we can't consent to that type of current client conflict. Now that we know that, let's remind ourselves of what the call of the question states. It says, it is proper for the attorney to do which of the following? So this is a situation where I would recommend that you read each answer choice and evaluate it rather than trying to articulate a precise answer on your own. So doing that, answer choice A says, ask the court for permission to withdraw from representing both women because the interests of the women are directly adverse to one another. Given what we previously discussed, A looks like a pretty good answer choice. It illustrates the point that we have this current client conflict and that it's not a consentable one because of the parties being directly adverse to one another. So let's hold on to answer choice A and evaluate those remaining choices. B says, get permission to withdraw from the court as the attorney for the woman who wants to take the plea deal and continue to represent the other woman who does not want the plea deal after getting the woman who wants the plea deal to consent to the attorney withdrawing. The attorney will also need to get informed consent in writing from the woman who does not want the plea deal in order to continue representation. Well, we know answer choice B is wrong because we can't fix this type of conflict of interest by the attorney simply withdrawing on one side. That doesn't work here. We've learned that based upon the rule that the lawyer cannot represent either person as a result of this conflict. So B doesn't really get us that outcome that we want. Let's evaluate C. It states, get permission to withdraw from the court as the attorney for the woman who does not want to take the plea deal and continue to represent the woman who wants the plea deal after getting the woman who does not want the plea deal to consent to the attorney withdrawing. The attorney will also need to get informed consent in writing from the woman who wants the plea deal in order to continue representation. So this is not a great answer choice either because it's essentially the opposite of what B says. And we've learned that B doesn't work because the lawyer needs to withdraw from representing both clients. So if B is wrong, that's going to make C wrong as well. Also, just a little tip, be on the lookout for answer choices like this where you have two that are basically identical but flip-flopped or reversed to one another. That's usually an indicator that they are both incorrect. And then finally, answer choice D says, continue to represent both women after they give their informed consent in writing. So this option doesn't work because, as we noted, this is not a consentable client conflict. So we can't move forward even if we get consent. So D is not the best answer. Therefore, answer choice A is correct. Let's move on to question 2. The facts state, an attorney represented a man in a breach of contract claim against the man's former employer. The attorney was able to obtain a settlement for the man without having to file suit. The employer paid the man in a lump sum, and the man paid the attorney his fee. The attorney did not do any other work for the man. About 6 months after the settlement with the employer, an attorney who represented the man's ex-wife called the attorney to inquire about the previous settlement, as the man was behind on child support. The attorney did not disclose any information to the ex-wife's attorney and instead called his client to explain the situation. Client told the attorney not to provide any information to his ex-wife's attorney. Is it proper for the attorney to furnish the information to the ex-wife's attorney? So stopping there, what rule is being tested by this question? Well, what's happening here is that the ex-wife's lawyer is calling the husband's lawyer and saying, I want information about this man's case. In other words, he wants confidential information. So this question is testing a lawyer's duty of confidentiality. So what does that rule specifically say? Well, the rule tells us that a lawyer shall not, so it's strong language, reveal information relating to the representation of a client unless the client gives informed consent or disclosure is impliedly authorized to carry out that representation, or there's an exception that's applicable. So let's stop there. Here, there are facts that make things very clear. This man did not give consent to his lawyer to disclose this information to his ex-wife's lawyer, meaning consent is not an option. So then we have to ask ourselves, is this a situation where there's implied consent, where the disclosure is impliedly authorized by virtue of the lawyer's need to carry out his representation? And the answer is again, no. And I can state that very confidently because here we're told that the lawyer is no longer working for the man. The man is a former client. So there's nothing that this lawyer needs to do to carry out the representation of the man since the representation is over. So this is not a situation where disclosure is impliedly authorized to carry out the representation because, as I mentioned, there is no current representation. So that leaves us with having to go through the exceptions to the duty of confidentiality. And there are 7. Before we turn to the exceptions, you should note that the rule makes revealing of this information permissive, not mandatory. And this is because the rule states, to the extent that a lawyer reasonably believes necessary, a lawyer may reveal information. The first exception is that a lawyer may reveal information to prevent death or serious bodily harm. Here, that's not what's going on. We don't have a situation talking about someone dying or someone getting really hurt. 2, to prevent a client's crime or fraud in which the lawyer's services have been used. And this exception doesn't seem to apply because the facts tell us that there is not an ongoing relationship between the attorney and the man. Again, the man's legal issue is over. Additionally, we're not given any facts that indicate the lawyer was used in any way to help this man get out of his responsibilities relating to his children and their support. So this exception doesn't apply. The next exception is to mitigate or rectify injury resulting from a client's crime or fraud in which the lawyer's services have been used. Similar to our discussion of the previous exception, it does not appear that the man used the lawyer to commit any sort of crime or fraud. Thus, the lawyer was not used in this way and does not have to rectify any action by disclosing information. The next exception is to secure legal advice about complying with the model rules of professional conduct. Turning to the facts on this point, we do not have any that support there being an ethical dilemma where the lawyer needs to reveal information to get guidance about his compliance with these rules. The next exception is that the lawyer may reveal information if in a controversy with the client that arises out of their client-lawyer relationship. But again, there are not any facts to support the idea that the man and the lawyer have any sort of dispute between the two of them that would allow the lawyer to reveal information to defend himself. The next exception is to comply with law or a court order. And again, the facts do not indicate that this is applicable. Finally, the last exception is to detect and resolve conflicts of interest. And again, this is simply not relevant to our fact pattern, as the lawyer is not faced with determining if a conflict of interest is present. So, as always, let's revisit that call of the question. Is it proper for the attorney to furnish information to the ex-wife's attorney? Based upon our discussion, the answer is no, because the client did not consent to the revealing of information, and there is no implied consent, and none of the exceptions to the duty of confidentiality are applicable. So let's take it from the top and evaluate A. A says yes, because the attorney may reasonably believe that disclosing this information would prevent the client from committing a crime. A is wrong. First of all, we're looking for a no answer, and this is a yes answer. But A is also wrong because this is not exactly what our exception says. The exception states a lawyer can reveal information to prevent a client's crime or fraud in which the lawyer's services have been used. Here, there are no facts indicating that he has used or is using this lawyer to commit a crime or fraud. So A is wrong. B says yes because disclosure is necessary to carry out the representation of the client. And B is wrong because it's all about timing. Here, the lawyer's representation of this man is over, meaning there is no continued representation. So there's no reason to make this disclosure. C says no, because the client told the attorney not to provide the information. And C looks pretty good. It speaks directly to one of the issues of consent, which we know the lawyer does not have. So let's hold on to choice C and evaluate D. D says no, because the attorney did not reasonably believe that disclosure of this information would prevent reasonably certain death or substantial bodily harm. Well, D is wrong because this is just one exception of many, and it's inapplicable. Therefore, that makes answer choice C the correct answer. Turning to question 3, the facts state, an attorney was representing a plaintiff, a popular musician, against a famous actor in a divorce action. Since both the plaintiff and the defendant were famous, the lawsuit received a lot of publicity. The attorney and the plaintiff had reached an agreed upon hourly rate at the beginning of representation, and the attorney was billing the plaintiff throughout the case. Recently, during a conversation between plaintiff and the attorney, the plaintiff explained that she was running out of money paying the attorney. Plaintiff offered to give attorney the media rights to any and all books, movies, or television programs based on the litigation as payment for representation. The attorney responded by telling the plaintiff to consult a different attorney to make sure the offer was in her best interests and that they could discuss the arrangement in a couple of days. The plaintiff sought independent legal advice on the issue and assigned all media rights to the attorney a few weeks later. The attorney had the plaintiff give informed consent in writing upon agreement to assign attorney the media rights. Is the attorney subject to discipline if he agrees to plaintiff's offer? The rule that's being tested in this question is another conflict of interest rule. And more specifically, this rule tells us that prior to the conclusion of the representation of a client, a lawyer shall not make or negotiate any sort of agreement that gives the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. Here, the facts make it pretty clear that this client is running out of money and she can't stay up to date on her bills with this lawyer. So she's willing to assign her rights to any sort of media portrayal later. And what's problematic is that the divorce is ongoing. And the rule specifically states that if the representation is ongoing, then this type of arrangement is not allowed. So that means the lawyer can't enter into this agreement, even if there's a signed writing, even if another lawyer gets involved to look out for the client's best interests. Those things don't matter here. This is simply a prohibited transaction. So let's revisit the call to question. It says, is the attorney subject to discipline if he agrees to plaintiff's offer? And the answer is going to be yes, because according to the rule, if the matter is ongoing, these types of agreements are prohibited. So let's look at our answer choices and evaluate them in order. Answer choice A says yes, because this fee structure would likely give the attorney a fee that is not considered reasonable. So A misses the rule being tested. While fee agreements do need to be reasonable, we aren't entirely sure what type or how much money this agreement would generate for the lawyer. But more importantly, we are positive that this type of agreement is generally prohibited. So A misses that point. A is wrong. B says yes, because the attorney is still representing the plaintiff as the matter is ongoing. And B looks pretty good. It speaks directly to the issue that appears to be tested. So we're going to hold on to B while we evaluate those remaining choices. C says no because the client gave informed consent in writing to the arrangement or to the agreement. C is wrong. It doesn't matter if the client consented to this because this is a prohibited transaction. This is not consentable. So C is wrong. And D says no, because the attorney told the plaintiff to seek independent legal advice and then waited a couple of days before entering into the agreement. And D, much like C, is wrong, because this is not consentable. And getting another lawyer involved or getting your client to sign something does not make it okay. It's generally prohibited, making B the best answer to this question.